Hello everyone. The topic for today's lecture is the Insolvency and Bankruptcy Code 2016. The objectives of this lecture are to make the students understand about the insolvency and bankruptcy, to discuss the key objectives of the IBC 2016, and to analyze the various provisions of the Insolvency and Bankruptcy Code 2016, particularly Part 2 of the Code. Insolvency is a situation where individuals or companies are unable to repay their outstanding debt. Bankruptcy, on the other hand, is a situation whereby a court of competent jurisdiction has declared a person or other entity insolvent, having passed appropriate orders to resolve it and protect the rights of the creditors. It is a legal declaration of one's inability to pay off debts. Insolvency and Bankruptcy Code 2016 was implemented through an Act of Parliament and got President's assent in May 2016. Due to banks' large piles of non-performing loans and delays in debt resolution, the law was necessary. In comparison to other nations like the United Kingdom, where the average time to resolve an insolvency is 1 year, and the United States of America, where the average time to resolve an insolvency is 1.5 years, India's average time to resolve an insolvency is 4.3 years. This time frame is intended to be reduced while also facilitating the resolution of big-ticket issues. According to the Insolvency and Bankruptcy Code 2016, this act was enacted to consolidate and amend the laws relating to reorganization and insolvency resolution of corporate persons, partnership firms and individuals in a time-bound manner for maximization of assets, promotion of entrepreneurship, availability of credit, and balance the interests of all stakeholders, including alteration in the order of priority of payment of government dues, as well as to establish an Insolvency and Bankruptcy Board of India. The Code repeals the Presidency Towns Insolvency Act 1909 and Provincial Insolvency Act 1920 and further amends various legislation including the India Partnership Act 1932, the Central Excise Act 1944, the Income Tax Act 1961, Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, Sikh Industrial Companies Special Provisions Repeal Act 2003, Limited Liability Partnership Act 2008, and the Companies Act 2013. All other laws pertaining to insolvency proceedings will be superseded by this comprehensive code, which covers all aspects of insolvency proceedings. Any petition that falls within the purview of the adjudicating authority as defined by the code cannot be heard by any additional civil court or other authority. Now, the key objectives of the code. The objective behind Insolvency and Bankruptcy Code 2016 are to consolidate and amend the laws relating to reorganization and insolvency resolution of corporate persons, partnership firms and individuals, to fix time periods for execution of the law in a time-bound settlement of insolvency, that is 180 days, to maximize the value of assets of interested persons, to promote entrepreneurship, to increase the availability of credit, to balance all stakeholders' interest, including alteration. Balance to be done in the order of priority of the payment of government dues. To establish an Insolvency and Bankruptcy Board of India as a regulatory body for insolvency and bankruptcy law. To establish higher levels of debt financing across a wide variety of debt instruments. To provide painless revival mechanism for entities. To deal with cross-border insolvency. To resolve India's bad debt problem by creating a database of defaulters. The Insolvency and Bankruptcy Code 2016 consists of 255 sections divided into 5 parts. Part 2 of the Code talks about the insolvency resolution and liquidation for corporate persons. Now the corporate insolvency resolution process. Under Section 6 of the IBC 2016, where any corporate debtor commits a default, a financial creditor, an operational creditor, or the corporate debtor itself may initiate corporate insolvency resolution process in respect of such corporate debtor in the manner as provided under Chapter 2 of this Code. Under Section 7 of the IBC 2016, a financial creditor, either by itself or jointly with other financial creditors, may file an application for initiating corporate insolvency resolution process against a corporate debtor before the adjudicating authority when a default has occurred. The financial creditor shall make an application under subsection 1 in such form and manner and accompanied with such fee as may be prescribed. The financial creditor shall, along with the application, furnish record of the default recorded with the information utility or such other record or evidence of default as may be specified. The name of the resolution professional proposed to act as an interim resolution professional and any other information as may be specified by the board. The adjudicating authority shall, within 14 days of the receipt of the application under subsection 2, ascertain the existence of a default from the records of an information utility or on the basis of other evidence furnished by the financial creditor under subsection 3. Where the adjudicating authority is satisfied that a default has occurred and the application under subsection 2 is complete and there is no disciplinary proceedings pending against the proposed resolution professional, it may, by order, admit such application, or default has not occurred or the application under subsection 2 is incomplete or any disciplinary proceeding is pending against the proposed resolution professional, it may, by order, reject such application. The corporate insolvency resolution process shall commence from the date of admission of the application under subsection 5. The adjudicating authority shall communicate the order under clause A of subsection 5 to the financial creditor and the corporate debtor. The order under clause B of subsection 5 to the financial creditor within 7 days of admission or rejection of such application as the case may be. According to section 12(1), the corporate insolvency resolution process shall be completed within a period of 180 days from the date of admission of the application to initiate such process. Section 15 of the Code says that there shall be public announcement of corporate insolvency resolution process. According to Section 16, the adjudicating authority shall appoint an interim resolution professional within 14 days from the insolvency commencement date, and the term of the interim resolution professional shall not exceed 30 days from date of his appointment. According to Section 17, from the date of appointment of the interim resolution professional, the management of the affairs of the corporate debtor shall vest in the interim resolution professional. Now the liquidation process. Liquidation is a process wherein the corporate debtor is dissolved or wound up. Dissolution or winding up of the corporate debtor means that will cease to exist or close down completely. Under the IBC, the process of liquidation is initiated when the corporate debtor becomes incapable of repaying its debts and carrying on its business in the ordinary course. The settlement of its debts is done by selling the assets of the corporate debtor and distributing the proceeds of the sale to its creditors, workmen, shareholders, partners, and in some cases to the government. Once the order of dissolution has been passed by the adjudicating authority, the officers, employees, and workmen of the corporate debtor will be discharged from their respective duties and responsibilities. However, the said persons shall not stand discharged if, during the liquidation process, the liquidator continues the business of the corporate debtor. Moreover, after the process of liquidation of the corporate debtor has been initiated, A moratorium will be declared against the corporate debtor, stating that the corporate debtor cannot sue or be sued before any court of law. However, the liquidator may institute a legal proceeding on behalf of the corporate debtor only with the permission of the adjudicating authority. It is pertinent to note that the aforesaid conditions shall not apply to the proceedings notified by the central government. Section 33 of the Code provides for the initiation of the liquidation process. Liquidation of the corporate debtor can take place under the following circumstances. If the adjudicating authority does not receive a resolution plan for the corporate debtor before the expiry of the maximum time period permitted by the IBC for the completion of the resolution process. In the case of Parimar Enterprises Private Limited versus Atlantis Life Sciences Private Limited, the Honorable Adjudicating Authority ordered the liquidation of the corporate debtor as the maximum period prescribed by the Code for completion of corporate insolvency resolution process had lapsed. In the case, even after 5 COC meetings, a resolution plan for the corporate debtor was not finalized and presented before the adjudicating authority, and the time period for CIRP has already lapsed. If the adjudicating authority rejects the resolution plan due to non-compliance with the requirements specified under Section 31 of the IBC. Section 31 of IBC deals with the approval of the resolution plan for the corporate debtor. As per the said provision, the adjudicating authority shall approve the resolution plan for the corporate debtor only when it is satisfied that such plan has been approved by the Committee of Creditors, hereinafter referred to as COC, by a majority of at least 66% of voting share. In the case of Rajputana Properties Private Limited versus Ultra Cement Limited and others, it was held that the adjudicating authority is empowered to reject the resolution plan and it can order the liquidation of the corporate debtor as prescribed by Section 33(1) of the IBC. If the resolution professional, before the confirmation of the resolution plan, informs the adjudicating authority that the Committee of Creditors has decided to liquidate the corporate debtor by at least 66% of the voting share. In the case of Punjab National Bank versus Sri Guru Prabha Power Limited, the COC had passed a resolution for initiating the liquidation process of the corporate debtor with a 100% majority. The Honorable Tribunal opined that the COC has exercised its commercial wisdom and thus it ordered for the liquidation of the corporate debtor. Subsequently, in the case of K. Shashishar versus Indian Overseas Bank and others, the Honorable Apex Court observed that the adjudicating authority is not empowered to inquire into the commercial decision of COC to initiate the liquidation process of the corporate debtor if the decision is passed by a majority of 66% as prescribed by Section 33(2) of the Code. The Honorable Apex Court in the case of Committee of Creditors of Essar Steel India Limited versus Satish Kumar Gupta and others held that the adjudicating authority has only a limited judicial review power in respect of the decisions made by the COC. The Honorable NCLT and Honorable NCLAT are not empowered to exercise their respective jurisdiction to interfere in the decisions of the COC taken by the majority of the members. If the corporate debtor or any other person whose interests are prejudicially affected contravene the resolution plan approved by the adjudicating authority. The Honorable NCLAT in the case of Yawardhalla versus JM Financial Asset Reconstruction Company Limited and others, wherein the resolution applicant failed to make some financial contribution as per the resolution plan, observed that if the terms of the resolution plan are not complied with, the corporate debtor shall go through the process of liquidation as laid down in Section 33, subsection 3 of the IBC. Once the order of liquidation has been passed by the adjudicating authority, it shall issue a public notice saying that the liquidation process of the corporate debtor has been initiated. Now the steps for liquidation process. Step 1 is the appointment of liquidator. Once the liquidation has been initiated, a liquidator will be appointed to carry out the liquidation process and manage the other affairs of the corporate debtor. Usually, the resolution professional appointed for conducting the insolvency resolution process is also appointed for the purpose of liquidation. Regulation 3 of the liquidation regulation mentions the eligibility criteria for an insolvency professional to be appointed as a liquidator. The powers and duties of the liquidator have been prescribed by Section 35 of the IBC. It includes verification of claims by the creditors, evaluation of the assets of the corporate debtor, carrying on the business of the corporate debtor, taking into his or her custody the assets of the corporate debtor, etc. Step 2 is the public announcement by the liquidator. After the appointment, the liquidator has to issue a public announcement within 5 days from the appointment in Form B of Schedule 2 of the liquidation regulations. Form B of the Schedule 2 prescribes the format in which a public announcement is to be issued. The purpose of the public announcement is to call upon the creditors and other such persons to submit their claims in relation to the corporate debtor. Step 3 is consolidation and verification of claims. The creditors of the corporate debtor have to send their claims within 30 days from the initiation of the liquidation process. After the receipt of the claims, the liquidator shall verify those claims submitted by the creditors. The liquidators may also ask the creditors to submit any evidence in relation to their claims for the purpose of verification. Step 4 is admission, rejection, and determination of the valuation of claims. A liquidator is empowered to either admit or reject the claims on the basis of his or her verification. If the liquidator rejects or admits a claim of a creditor, he or she has to communicate the same to the creditor as well as the corporate debtor within 7 days from such decision. After all the required claims have been admitted by the liquidator, he or she has to determine the value of the claims for the purpose of distribution of the assets of the corporate debtor. Step 5 is time limit for liquidation proceedings. As per Regulation 47 of the liquidation regulations, the liquidation proceedings should be completed within 1 year from the date of initiation of liquidation as opposed to the extendable time limit of 330 days for the resolution process. Regulation 47 of the liquidation regulations prescribes the model timeline for the liquidation process. Step 6 is dissolution of the corporate debtor. The adjudicating authority on the application of the liquidator after the distribution of assets of the corporate debtor as per the priority of claims shall dissolve the corporate debtor. Next step is the appeal against the liquidator. As per Section 42 of the IBC, a creditor who is aggrieved by the decision of the liquidator may file an appeal to the adjudicating authority within 14 days of the communication of such decision to the creditor. Now, offences and penalties under Part 2 of the Insolvency and Bankruptcy Code 2016. Section 68 says punishment for concealment of property. Where any officer of the corporate debtor does certain acts to conceal property, such officer shall be punishable with imprisonment for a term which shall not be less than 3 years but which may extend to 5 years, or with fine which shall not be less than 1 lakh rupees but may extend to 1 crore rupees or both, provided that nothing in this section shall render a person liable to any punishment under this section if he proves that he had no intent to defraud or to conceal the state of affairs of the corporate debtor. Section 69 provides for the punishment for transactions defrauding creditors. On or after the insolvency commencement date, if an officer of the corporate debtor or the corporate debtor has defrauded his creditors, such officer of the corporate debtor or the corporate debtor, as the case may be, shall be punishable with imprisonment for a term which shall not be less than 1 year, but which may extend to 5 years, or with fine which shall not be less than 1 lakh rupees, but may extend to 1 crore rupees or both. Section 70 provides for punishment for misconduct in course of corporate insolvency resolution process. On or after the insolvency commencement date, where an officer of the corporate debtor does not disclose to the resolution professional all the details of property of the corporate debtor and details of transactions thereof, or any such other information as the resolution professional may require, or does not deliver to the resolution professional all or part of the property of the corporate debtor in his control or custody and which he is required to deliver, or does not deliver to the resolution professional all books and papers in his control or custody belonging to the corporate debtor and which he is required to deliver, or fails to inform their solution professional the information in his knowledge that a debt has been falsely proved by any person during the corporate insolvency resolution process, or prevents the production of any book or paper affecting or relating to the property or affairs of the corporate debtor, or accounts for any part of the property of the corporate debtor by fictitious losses or expenses, or if he has so attempted at any meeting of the creditors of the corporate debtor within 12 months immediately preceding the insolvency commencement date, he shall be punishable with imprisonment for a term which shall not be less than 3 years, but which may extend to 5 years, or with fine which shall not be less than 1 lakh rupees, but may extend to 1 crore rupees, or with both, provided that nothing in this section shall render a person liable to any punishment under this section if he proves that he had no intent to do so in relation to the state of affairs of the corporate debtor. If an insolvency professional deliberately contravenes the provisions of this part, he shall be punishable with imprisonment for a term which may extend to 6 months, or with fine which shall not be less than 1 lakh rupees but may extend to 5 lakh rupees, or with both. Section 71 provides for punishment for falsification of books of corporate debtor. On and after the insolvency commencement date, where any person destroys, mutilates, alters or falsifies any books, papers or securities, or makes or is in the knowledge of making of any false or fraudulent entry in any register, books of account or document belonging to the corporate debtor with intent to defraud or deceive any person, he shall be punishable with imprisonment for a term which shall not be less than 3 years, but which may extend to 5 years, or with fine which shall be not less than 1 lakh rupees, but may extend to 1 crore rupees, or both. Section 72 provides punishment for willful and material omissions from statements relating to affairs of corporate debtor. Where an officer of the corporate debtor makes any material and willful omission in any statement relating to the affairs of the corporate debtor, he shall be punishable with imprisonment for a term which shall not be less than 3 years, but which may extend to 5 years, or with fine which shall not be less than 1 lakh rupees, but may extend to 1 crore rupees, or with both. Section 73 provides punishment for false representations to creditors. Any officer of the corporate debtor shall be punishable with imprisonment for a term which shall not be less than 3 years, but may extend to 5 years, or with fine which shall not be less than 1 lakh rupees, but may extend to 1 crore rupees, or with both. Section 75 provides punishment for false information furnished in application. Where any person furnishes information in the application made under Section 7 which is false in material particulars, knowing it to be false, or omits any material fact, knowing it to be material, such person shall be punishable with fine which shall not be less than 1 lakh rupees, but may extend to 1 crore rupees. Section 76 provides punishment for non-disclosure of dispute or repayment of debt by operational creditor. Where an operational creditor has willfully or knowingly concealed in an application under Section 9 the fact that the corporate debtor has notified him of a dispute in respect of the unpaid operational debt or the full and final repayment of the unpaid operational debt, or any person who knowingly and willfully authorized or permitted such concealment under Clause A, such operational creditor or person, as the case may be, shall be punishable with imprisonment for a term which shall not be less than 1 year but may extend to 5 years, or with fine which shall not be less than 1 lakh rupees but may extend to 1 crore rupees, or with both. Section 77 provides punishment for providing false information in application made by corporate debtor. Where a corporate debtor provides information in the application under Section 10 which is false in material particulars, knowing it to be false, and omits any material fact knowing it to be material, or any person who knowingly and willfully authorized or permitted the furnishing of such information under subclause A, such corporate debtor or person, as the case may be, shall be punishable with imprisonment for a term which shall not be less than 3 years but which may extend to 5 years, or with fine which shall not be less than 1 lakh rupees but which may extend to 1 crore rupees, or with both. So, this was all about the various provisions of Part 2nd of the Insolvency and Bankruptcy Code 2016. Hope you have understood the lecture. Thank you for watching.